Good morning and good afternoon, everyone. Thank you so much for joining us from across the country for our annual federal sector update. It's the third of our seminar series this fall, and there are a few more to come still. So if you have any interest in checking those out, please look on our website under Fasken Institute for more info. I'll introduce myself quickly. For those of you who don't know me, my name's Jackie VanDerMeulen. I'm a partner in our Toronto Labor and Employment Group here at Fasken, and I work primarily in the federal sector. I was really pleased to see so many familiar names on our registration list. So we're really happy to have you. Thank you. While I introduce the rest of our panel, I'll get you to look, please, at some of the housekeeping matters on the screen. You'll see that we are taking questions. We love your questions. We may answer some of them throughout, but we'll try and get to the rest of them at the end if we're not able to. Turning over to some of our other panelists now, I'll start with my colleague, Chris Pigott. Chris is a partner in the Toronto Labor and Employment Group as well. Chris has been very involved he was involved with CP Rail this summer with the Section 107 ministerial referral. He was very involved too, representing Canada Post in the charter challenge that the union filed to the back to work legislation in 2018, which seems like just yesterday. We just got the decision this summer, actually, so it does feel like yesterday in many ways. But Chris is going to talk to us a little bit about that area of the world because it's been, lots of developments this year in that front, let's say. Turning to one of our other panelists, I'm joined by Emilie Paquin-Holmested, who is a partner in our Montreal group. She's also co-leader of the Labor and Employment Group here at Fasken. Emilie was previously in-house at a federal sector employer, so has lots of interesting experience there and also practices extensively in the federal space now that she's returned to private practice for some time now. Turning second last, to my colleague Gillian Round, also a partner in our Toronto group here in the Labor and Employment Group. Gillian also spent some time in-house at a large FI, financial institution, so brings that experience, but works extensively with unionized employers too. And last but not least, certainly, we are delighted to be joined by our guest speaker today, Derrick Hynes, who is the president and CEO of FETCO. I think many of you in this space know Derrick already. But for those of you who don't, FETCO represents Canadian employers on labor and employment matters in the domestic space, but Derrick's also really active in the international space. FETCO is the Canadian employer representative to the International Labour Organization, and Derrick actually gets to sit on the governing body of that organization. So I'm hoping Derrick can share some of his insights about what's happening on that international space, particularly when we get into topics like gig workers, because I know there's a lot of discussion on the international stage on that front, right to strike as well. With those introductions aside, you'll see we've got a fairly packed agenda, as we always do, trying to summarize what's happened in the past year and what lies ahead for federal sector employers. So I won't spend too much time on the agenda, and instead I think I'll turn it over to Chris to get us started on the use of ministerial orders and the ban on replacement workers that's forthcoming. Chris?
Thanks very much, Jackie, and welcome everyone. So really to jump right in, one of the biggest stories in the federal sector this year, and indeed I think one of the biggest stories in the Canadian business world, has been a lot of work stoppages, both strikes and lockouts, really across the federal sector. And in turn, what we've seen is a lot of intervention by the federal government over the course of the last few months in particular to end those work stoppages and try to resolve the labor disputes through interest arbitration. And what's really interesting about what the federal government's been doing in this regard is that it hasn't been resorting to back to work legislation, as it has done for decades when it wants to end a federal sector labor dispute. Instead, the federal government's been using a new tool that exists within the Canada Labour Code, and that is Section 107 of the code. Section 107 is a very broadly worded provision that essentially says that the Minister of Labour may do anything that he or she wishes to do in the interests of preserving industrial peace or securing industrial peace. it's incredibly broadly worded. Now, I say new in scare quotes because Section 107 has actually been in the Canada Labor Code for decades, but it really hasn't been used at all, and certainly not to prohibit strike activity or lockout activity in a meaningful way. This is a new development. We've already seen it several times this year. Why might we be seeing this new development? Well, all of these disputes are happening at an interesting time in Canadian politics, where we have a Liberal minority government that's been supported by an NDP government. Obviously, NDP not inclined to favor, certainly support back to work legislation. But we also have a Conservative government that's, I think, demonstrated on a number of fronts that it's really not willing to help out the Liberal government in doing anything when it comes to passing legislation. So suffice to say, the current Liberal government has, I think, been forced to get creative and look at what tools it has in the existing toolbox that allow it to intervene in labor disputes without resorting to new back-to-work legislation. And that tool is Section 107 of the code. Now, as I mentioned, this is not, Section 107 has not been used as a one-off. It's been used multiple times already in 2024 to end work stoppage in the federal sector. And these have all been, I think, very highly reported on, very consequential business stories throughout the year. Just a couple of examples of the use of Section 107 in the last few months. We had a WestJet work stoppage in June. Then very big news over the course of a quiet summer, the strikes at both railways, CPKC and CN, at the same time, really resulting in a shutdown of the entire national rail network. And then just within the last few weeks, we've had another Section 107 order that has brought an end to strikes both in the BC ports and the Quebec ports. And again, that's just over a week ago, those orders were issued. So we're talking about a lot of different labor disputes here, but the Section 107 orders that we've seen the Minister of Labor introduce really have two key features, at least today. First of all, the order ends the strike and lockout, so expressly prohibits strike and lockout activity. The second key feature is that the 107 orders impose interest arbitration process to settle the terms of the new collective agreements. And what the orders, the way in which the orders do this is really by referring the matter to the Canada Industrial Relations Board, the CIRB, to deal with the logistical details of how that will all work. So for example, how will the interest arbitration process be structured? Who will be the interest arbitrator? What are the timelines for the arbitration going to be? All of that sort of detail is dealt with by the CIRB following the direction of the Ministry of Labor. Now, this is a story that's really just beginning. Despite the fact that we've had the Minister of Labor invoke Section 107 multiple times over the course of the last year and get into what I guess you could say is a bit of a pattern in terms of how Section 107 is used again to end the work stoppage and then second, refer the matter to interest arbitration, we're really just at the beginning of this story. And that's because, not surprisingly, there's been quite a lot of debate and controversy over the use of an existing provision within the code to restrict strike activity. And as this group will know, there's been a lot of attention on the right to strike in Canada over the course of the last decade or so, since the Supreme Court in 2015 recognized that workers have a constitutional right to strike. And as the Minister of Labor has used Section 107 to end strike activity, we've seen the Canadian union movement broadly really marshal arguments around the constitutional right to strike to try to challenge the minister's use of Section 107 to end labor disputes. And despite the fact that we're just a couple of months into this, we've already seen some very concrete litigation action happen in this area. So first, and I think most prominently, at least to date, the CIRB did issue a decision dealing with the use of Section 107 in the railway disputes. That decision was initially made in August in a bottom line decision, and we got the board's reasons in October 2024. In essence, what the unions had said there was that Section 107 can't possibly be used by the minister to prohibit strike activity, because doing that would violate the constitutional right to strike protected under Section 2D of the Charter. The railways responded, and ultimately the board dismissed the union's challenge, really on what some would call a technical basis, but I think it's an important procedural grounds. And specifically what the board said was that because we're dealing with a ministerial decision, use of discretion by the minister to do something, that challenge can only be brought within the federal court as an application for judicial review. And indeed, the federal court has the exclusive jurisdiction to review this type of ministerial order. So the board didn't say that, all of this is clearly constitutional, there's nothing to see here, but it did say that the unions are going to need to proceed to court in a fairly drawn-out litigation process if they want to challenge the use of Section 107. Interestingly, the board in its railway decision did, I think, express some concern about the use of Section 107 to prohibit strike activity. The board certainly didn't make any findings in this regard, but it did note some of the history around the use of Section 107 and the prior use of back to work legislation. I think basically sending a signal that these matters will require, I think, some litigation in the courts to finally resolve. And we're going to get that litigation. The Teamsters Union, the TCRC, which represents employees at both railways, has brought litigation in the federal court to challenge the minister's Section 107 orders. And those proceedings are in the federal court as we speak. They may take years to resolve. There's a lot of evidentiary work, a lot of different interveners who are all jumping into what's going to be, I think, a fairly lengthy litigation process in the federal court to deal with the railways orders. We've also seen the unions on the West Coast challenge the very recent Section 107 order that the ministers made within the last week or so to bring an end to the port stoppages on both the West Coast and in Quebec. That proceeding is going to work its way both through the CIRB over the next few weeks and within the federal courts. So suffice to say that we have not heard the end of the story on Section 107, and we're going to see, I think, some very interesting litigation and decisions concerning the minister's power to intervene in this way over the next little while. Derrick, would you like to jump in here?
Yeah, sure. Thanks, Chris. I mean, obviously, on behalf of the broader employer community in the federal space, we've been very active over the past 12 months or so on this issue. We were supportive of, encouraging of the minister to intervene in this way, particularly in both the rail and the ports disputes. Argument being, yes, there is a fundamental right to collective bargaining and a right to strike, but those things cannot be without limit. And our sense was those situations where bargaining had gone on for so long and did not appear to be progressing, that we felt, given the potential very negative economic impact nationally that a shutdown of both Canadian ports or both Canadian railways was going to have on Canadians writ large, that it was incumbent upon the minister to intervene. Agree with you that this is going to be a very interesting process that we will follow closely and intervene in to see where it lands. But we do think that in these situations, the minister, the government, does require some tools in his toolkit to move things along when bargaining appears to be completely broken down. Therefore, we definitely support the minister's move in this space, and we'll follow it closely.
I think that's a really important point. And I think that the last thing I'll say about Section 107 right now, we do have case law emerging from the courts with respect to the use of back to work legislation in the last few months that has found, including in the case of federal sector back to work orders, that the government can prohibit further strike activity and send a dispute to interest arbitration when the collective bargaining, or the parties in collective bargaining, are truly at an impasse and collective bargaining isn't going to result in a deal. Now, those decisions are under appeal in Ontario right now, so there's a bit more of a stay tuned there. But bottom line, the current case law does support the position that Derrick has just outlined.
Yeah, Chris, just if I could just add one more piece, I think it's important to correct the record here because there is a message, I think, coming from the union side that this referral to binding arbitration is some employer-friendly alternative. I think just like any union, no employer wants its collective agreement to be written by a third party. So this is not really an ideal state from our perspective as much as it is from the perspective of the union side. But the argument we have made to the minister is that in these very extreme circumstances where things have clearly broken down and the impact is just enormous, he has to step in, and this is an alternative that we can pursue, we believe, under the current rules as provided under the code.
Turning to a related issue that's going to have a very significant impact on work stoppages moving ahead in the federal sector, we wanted to update everyone on what's been happening with Bill C-58, and that's the legislated ban on the use of replacement workers in strikes and lockouts. Now, as some of you will undoubtedly recall, Bill C-58 was not the first proposed legislation to prohibit federal sector replacement workers. Indeed, there's been dozens, literally, of initiatives over the past few decades where a party, often the NDP, often the Bloc, has proposed a legislative ban. And those bans have invariably failed because the Liberals and Conservatives have voted them down in Parliament. But interestingly enough, Parliament may not be interested in back to work legislation right now, but it seems to be quite interested in breaking some legislative ground with respect to actually adopting a proposed ban on federal sector replacement workers. And indeed, Bill C-58 was passed and granted royal assent in June of 2024. What Bill C-58 will do, effective June 2025, is impose a very broad ban on the use of replacement workers during federal strikes and federal sector strikes and lockouts. What's really interesting about the legislative history here is not only that the bill received all party support. Yes, that's right. The Conservatives supported the prohibition on replacement workers, as did many Liberal MPs who had voted against this kind of legislation in the past. Not only did it receive all party support, but as the bill moved through the legislative process in the last few days, the last few months of its journey, it actually was amended to broaden and strengthen the ban. In other words, this was a legislative story that kept really getting worse for employers throughout the process. But it was ultimately enacted, and it will come into force in June 2025. What exactly is it going to do? Well, in a nutshell, it's going to ban several broad categories of workers from providing assistance to an employer that's facing a strike or lockout. And so the prohibition is going to extend to any employee, including non-union employees and management, who's hired after notice to bargain is given. So it's not after the strike or lockout has begun. It's actually at the very beginning of the collective bargaining process, after notice to bargain has been given. It's also going to prohibit any employee who is hired before notice to bargain from working. So very broad prohibition. if that employee normally works at a different location of the employer. Also, any contractor being retained before or after bargaining will be prohibited from working, as will any volunteer, student, or member of the public. So all of those federal employers who are bringing their grandparents in to volunteer to continue operations, that will no longer be kosher after June 2025. And I say this quite glibly, but really this prohibition is incredibly broad. And there are very limited exceptions to the prohibition. One, I think, a potentially important exception relates to contractors who have been working for an employer since before notice to bargain was given. They can continue working, provided they are only doing the same work that they did before notice to bargain was given. In other words, you can keep that contractor on doing the work they've always done, but you can't ramp up their work to account for the loss of the struck employees or the locked out employees. You can't get them to do different work that needs to be done during the strike or lockout. They need to be doing the same work that they've been doing since before notice to bargain was given. There are also exceptions where there is going to be an imminent or serious threat to health and safety, or damage to personal property, or environmental damage. Just note, though, this is not any damage to personal property. This is not any threat to safety. It must be an imminent or serious threat. Again, signaling that the government's really setting a high bar for the use of replacement workers under this legislation. Finally, the consequences of a violation are serious. These are not technical breaches we're looking at. A violation will constitute an unfair labor practice. And in the most egregious cases, we could see fines of up to $100,000 per day for the employer. So some extremely serious consequences for employers who breach the prohibition on replacement workers. Derrick, can I ask you to jump in on this?
Yeah, well, Chris, you're rubbing salt in a very fresh wound. Obviously, the employer community rallied around this bill, as we have done, as you noted, dozens of times in the past, to try and either make this go away or somehow soften the blow of it, if you will. And the wound is still fresh because we lost, frankly, on almost every bit of the fight. The piece on this slide that we did try to add in the latter stages when the bill was at committee was around the exception when there's a threat to, the national economic interest or national economic security. We could not engage elected officials in a discussion that would somehow create that threshold, which we think would give employers some wiggle room to continue providing vital services in the event that there's a strike or a lockout. So yeah, this one is a massive disappointment. We think it is it got a lot of political momentum, and my read of this politically is voting against this would be seen to be voting against the worker, if you will. Ergo, all party support for this piece of legislation, which we believe is very flawed and will have very significant consequences moving forward, particularly in the context of what we've seen over the past 12 to 18 months with this labor instability. This is not going to make things better. It will only make things worse. And I guess time will tell how worse it will get.
I think that's an important point, Derrick. And I think the evidence that we do have from BC and Quebec, which both at the provincial level have had long-standing prohibitions on replacement workers, is that a ban like this makes strikes more frequent. It makes strikes and lockouts longer, and generally does not contribute to or otherwise facilitate speedy and effective collective bargaining. I think what's really interesting is that we've got a legislature, a parliament, that seems willing to take legislative action on this front, but not with respect to back to work legislation. And in my view, what this ban is going to do is really increase instability, probably increase the number of federal work stoppages we see, including across the critical national infrastructure, and probably necessitate even more government intervention than we've seen over the course of the past 12 months or so. I'm going to turn next to some comments on new legislative requirements outside of the labor context. Emilie?
Yes, thank you very much. Hi, everyone. Thanks for joining us today. So last year has been a very big year in federal employment law. Federal government has passed a number of significant amendments to the Canada Labor Code. So in this next section, I'll address some of the key modifications that have come. And these include disconnecting from work policies, gig worker protection, and misclassification protections, and expanded leave entitlements. Andrea, can I ask you to just move on to the next slide, please? Thank you. So to start off, we'll start off by speaking about Bill C-69. So Bill C-69, that's also called Budget Implementation Act, was introduced in May 2024 by the federal government. The act introduced an important amendment to the Canada Labor Code, which some say aims to appeal to a younger generation of workers and of voters, and this is the right to disconnect. So in the post-COVID era, the right to disconnect has been a growing trend outside of Canada. It's made its first introduction in Canada through Ontario legislation, where we've seen an introduction a few years ago to an obligation for employers to have a disconnecting from work policy. This year, the federal government has followed suit, introducing this new requirement for federal employers to have a policy of this nature, so disconnecting from work policy and other related obligations. It's important to note that the Act does not provide for a standalone right to disconnect. So that's not on the table here. It's also important that the new obligations have not come into force yet, but will come into force sometime in 2025. The objectives of these amendments relating to the right to disconnect are really related to increasing the well-being of employees and the productivity of employees in federal undertakings. Under the Act, disconnecting from work policies will have to include a general rule regarding work-related communications outside of scheduled work hours. It will also have to include employers' expectations around communication outside of scheduled hours of work. Also, employers will have to provide any opportunity to disconnect from means of communication and any exception to the rule with their underlying rationale. The employers will have 1 year from the date of the requirement comes into force to develop such a policy, and will have to consult employees to develop their policy in this regard. The policy will then have to be updated every 3 years and will have to be posted in the workplace. The code, it's important to note that the amendments regarding this new policy does not apply to employees who are managers or who are members of certain professions that are determined by regulation. Also, the new provisions relating to the right to disconnect will prohibit reprisal or threats against employees who will ask an employer to comply with their disconnecting from work policy, who ask about their rights under the policy, who exercise or attempt to exercise a right under the policy as well. The federal government has announced that information, tools, and resources will come out before the coming into force of this new obligation. So stay tuned on that information, which will help guide employers. I believe Jackie has something to add.
Yeah, well, I was curious to hear from Derrick more than anything. Like, is this a gateway drug? Is this the start of are we going to see first a policy requirement and then we're going to see layers come into effect in future years? What are you hearing?
Well, I mean, if I can be cynical for a moment, this has been a long time coming. The government has been talking about this for probably 7 or 8 years. And the cynic in me sees that this is something that sort of started in the international space, and it was a shiny object, I believe, that the current government saw as an opportunity to do something similar within the Canadian context. There was a long period of consultation that led to this decision, which actually occurred during the COVID time period. The point that we had made throughout this entire process is this is in many respects just another one of those examples of a solution looking for a problem to solve. Many of the employers, the large employers, particularly in the federal private sector, are heavily unionized. Many of them are 24/7 continuous operations. This sort of requirement is going to be very complicated and could be dealt with through the collective bargaining process in specific organizations where they feel this is an important item. I guess the small win that came from this is this legislation actually at this point only requires that an employer will have to have a policy. So we haven't gotten so far as to be prescriptive around things like, shutting down servers at 6 o'clock or not allowing employers to reach out to their employees after hours. We may get there. I don't know. Still lots of unknowns. To Emilie's point, we're still awaiting guidance. This is not yet in force. So we're going to follow this one closely and try and ensure the employer perspective is still heard loud and clear.
Awesome. Thank you very much, Derrick. Now just moving on to the gig worker protection, a few introduction words. So, this has really been a big law theme in 2023, 2024 in Canada. We've seen an increase in legislation that aims to protect individuals who are engaged in digital platform-based work, or who are what we call gig workers. We've seen legislation in Ontario and BC already. And this includes, so gig workers include rideshare drivers, food delivery drivers. We see also independent couriers and delivery persons for various services. So it's really an economy that has been englobing and covering more and more people across the world, really. And so we've seen an exponential growth in the number of employees in the sector. The International Labour Organization has described the emergence of the gig economy as one of the most important transformations in the world of work. And in Canada, there are certain studies that have established that in 2023, 28% of Canadian adults have been involved in the gig economy. And Derrick, I don't know if you've heard similar statistics on your end, but I thought that was a pretty impressive number to see.
Well, I mean, this one is a real challenging issue for a couple of reasons. One, the question that we keep asking the federal government is, who are these gig workers in the federally regulated private sector? There clearly are some employee classification issues within trucking, which one could argue maybe they're in the gig work space. But I think the government has actually made a commitment in partnership with the trucking industry to address that issue. Beyond that, we continue to have extraordinary difficulty trying to find out from the government who these gig workers are in the federal sector that they're actually creating new regulations for. I'm not going to argue that this is not an issue in the provincial space. I think it is. There definitely is, to your point, Emilie, an international trend here. There are countries around the world where the vast majority of their workers are in the informal space, and that is a challenge that needs to be addressed. On a related note, the International Labour Organization next year is going to start the first of a 2-year exercise to develop standard setting around gig work, platform work, which I think will find its way trickling into national legislative frameworks, and we may see some impacts flow into Canada. But for us, we do keep coming back to, we don't know what this is. We don't know who these workers are. And we've spent a lot of time in consultation talking about a problem that we don't really know what the problem is that we're trying to solve.
And that's an excellent point, Derrick, and that maybe reflects the amendments that were made by the federal government to try to structure and to protect these employees, which they're having a hard time to identify, to navigate. And so, in March 2023, we had the ministry who came out with a report that identified some of the risks that people involved in the gig economy were exposed to. One of the major ones being misclassification. There's lower pay, there's also health and safety concerns. But in the objective of trying to protect gig workers, the federal government has come and has added amendments to the Canada Labour Code more relating to, strengthening the prohibitions against employee misclassification. So that's kind of how the government has come to attempt to start addressing this this new reality that they are still maybe trying to comprehend and wrap their minds around. And so maybe just for the audience, what is employee misclassification? Employee misclassification is when an employer does not consider or treat a person who's an employee as an employee, but rather as an independent contractor, for example. And so this can result in an employee not receiving or not benefiting from some of the protections provided for the Canada Labour Code or other laws. Andrea, if I can ask you to move on to the next slide, please. So the amendments to the code relating to misclassification protection include things like a presumption that any person who's paid remuneration by an employer is an employee. And that is unless the employer can demonstrate otherwise. And so there's a big reversal of burden that has been legislated into the Canada Labour Code. This also applies in any proceeding, including unjust dismissal, where the employer who alleges that a person is not an employee, it is now provided that the employer bears the burden of proof to demonstrate that the person is not an employee. And it is also now an offense to misclassify an employee. And so there's important penalties that can be imposed upon employers who misclassify. And finally, individuals who believe they have been misclassified can file a complaint with the board. And so there's various new mechanisms to really, make the independent contractor classification harder to attain. It is the exception, and that exception needs to be clearly demonstrated by employers. These changes came into force in June 2024, so it's important for federal employers who do have independent contractors in their workplace to really review the analysis of whether these people are in reality independent contractors, making sure they meet those criteria. And lastly, there's another series of amendments that were introduced in the Canada Labour Code, this time through Bill C-59, that relate to pregnancy loss, bereavement, and placement of a child. I'm just looking at the time now. I may mainly all speak about the leave related to pregnancy loss. We'll move on bereavement leave pretty quickly. The slide is quite detailed, so I believe everyone's going to be receiving the slides afterwards. So I'll direct you to that, and I'll say a few words on placement of a child. So these amendments should come into force in December 2025, or they may also come into force before then if an earlier date is proclaimed. So regarding the leaves related to pregnancy loss, the Bill C-59 has introduced a new partially paid and protected leave for that specifically aim to protect or to provide these leaves for employees or their partners who have pregnancies that do not result in a live birth. So an employee that finds himself or herself in this situation may take a leave of 8 weeks in the event if the pregnancy results in a stillbirth after 20 weeks of pregnancy, or 3 days in any other case of pregnancy loss. The first 3 days of the leaves are paid, and they can be taken in 1 or 2 periods. It's interesting, this type of specific leave at the federal level appear to be coming at a much later time than the provinces have adopted these types of specific leaves. Interestingly, I was just looking in Quebec, this very specific leave related to pregnancy loss have been in place since 2002. So, the question comes up, what were we doing at the federal level before 2024? Well, often people and employees who found themselves in these situations would have to take a leave based on the medical leave or compassionate care leave. And so I think it's interesting. I think it's important that the federal government has modernized the Canada Labour Code to address this reality that affects numerous employees. As mentioned, the bereavement leave, I will let you review. It's really just updating the bereavement leave to make the criteria and the rules regarding bereavement leave to align with other types of leave in the Canada Labour Code. If we go on to the next slide, please. And the last type of leave that I will briefly discuss is the leave for placement of a child. So this is also a new protected leave for up to 16 weeks for employees who are welcoming children by adoption or a newborn child by surrogacy. It's important to note that when more than one employee are involved in the same placement of a child, they cannot take collectively more than 16 weeks. So the period does not multiply by 2 if 2 of your employees are involved in the same placement of a child. Also important to note that Bill C-59 has amended the Employment Insurance Act to allow employees to benefit from a 15-week employment insurance period. And so that's also an important point to add. And now I will pass the slides to Jackie, who will tell us a bit about pay equity updates.
Thank you very much, Emilie. And I think on leaves, if we end up seeing a new or change in government, I expect, well, at least past experience tells us that every time we get a new government come into power, we see lots of amendments to Part 3 of the code or whatever provincial employment standards laws may be applicable in the provincial context. So we'll see what happens between now and this time next year, but we'll keep you updated. Pay equity. So there has been a lot of activity in the pay equity space over the past year and a half in particular. I'm not going to go into sort of basic details of the act. I think we're hopefully all past that stage right now. Instead, I'm going to focus a little bit on what we're seeing, kind of key issues emerging at the moment, and then I'll turn it back over to Emilie to talk about maintenance activities and other things going forward. So what have we seen recently? There was a flurry of extension requests approved during this past summer and actually still going forward. So we've still seen the commission approving or the commissioner approving extension requests, even where those extension requests were filed after the September 3rd deadline that applied for most employers. So that's a good news story, I think, for employers for the most part. To committees and the unions and employee reps on those committees are supporting the extension request, recognizing this is a much bigger undertaking than I think most initially anticipated, and that there's value to getting it done right rather than fast. So that's good. Obviously, for those employers, though, if there are adjustments that are due in their pay equity plans, they're going to be making retroactive payments with interest. So it's not without cost, but it certainly allows you to spend the time to do it properly instead and to resolve issues, because we're starting to see some issues brew in committees that are still ongoing. We also saw another good news side of the story. We saw more requests for multiple plans granted than we were initially anticipating. For those of you who have been following this, initially we saw a lot of requests for multiple plans being denied by the commissioner. But of late, I think probably the benefit of coming late to the party is you get to adjust your approach and an application ultimately to reflect the jurisprudence that's coming out of the commission. So we have seen more employers who were able to get multiple plans, typically in really unique circumstances. And I've included some of those decisions there for those of you who are interested in following this. But at least, yeah, we're seeing some flexibility, still not opening the floodgates, but very, yeah, in niche circumstances, they are being approved. We're also seeing the commissioner grant requests from employers to establish committees that don't meet the strict composition requirements of the Act. So you may know that under the Act, there are requirements, for example, for 50% of the committee members to be female, for representatives from each of your bargaining agents to be on the committee, non-unionized employee representative, those sorts of things. Where for circumstances largely beyond the employer's control, they're not able to meet those requirements, the Pay Equity Commissioner has been granting their requests to establish committees that don't meet those. Oops. Oh, sorry, skipped ahead.
Jackie, could I just jump in there?
Of course you can.
Yeah, just on the multiple plan thing, as a lesson learned, which was a very expensive lesson learned, I think, for a lot of employers. I mean, I think as everybody on the call knows, the legislation requires that all employers have one pay equity plan. but there is language in the act that gives the commissioner some authority to allow more than one plan where she views the circumstances to warrant it. The challenge I think that we all experienced as a community is nobody really knew what the rules of the game were. So this act came into force in I would argue, a reasonably accelerated time frame. And I think many large, highly complex employers, particularly those that are heavily unionized with multiple bargaining agents, had assumed that they would fit the criteria for some of that exceptional opportunities that the commissioner might grant to let them do multiple plans. The challenge, of course, is that consumed months and months of time for them to prepare these multiple plan applications, which almost exclusively were rejected. And as the window started to close on the coming into force date of this legislation, most employers then were stuck trying to do catch up. And that's where we are today, where I would argue many, many employers have not hit the deadline and are seeking extensions. If we could go back in time, it sure would have been better had the commissioner been open to entertaining multiple plans, had they laid out some clear criteria that employers could follow and a process, clearly articulated process that they could go through to get these applications considered. Instead, as you just stated, those who came later learned, which is unfortunately not the best way to do this, and we ended up losing a whole bunch of time as a result.
Yeah, no, you're exactly right. And I do think too, it's been a moving target in terms of what kind of evidence is required. And I still can't discern from these cases, from the commissioner, sort of what the threshold is. In the Treasury Board case, it seemed to set a really high threshold for the type of evidence and expert evidence that would be required. But in subsequent cases, we're seeing much shorter decisions with no reference to that kind of evidentiary basis at all. So I'm still confused. Unfortunately, I wish we had, some more clear guidance and principles. But at least I'm cautiously optimistic that in some cases, these applications will be granted. Another really interesting case that I think is helpful for employers to note is this CIBC case, because it relates to a request from one of the union representatives on the committee for additional information and records from the employer. The case doesn't get into what kind of additional information and records those were, but I'm seeing a lot of these requests pop up across committees in the federal sector. And it's usually for things like, I want all the gender data going back X number of years. I want all the individual job titles that are being associated with job classes. I want all the elements of comp, etc. So I want every job description. I want all these sorts of things. The act doesn't get into the level of detail about what specifically could be required, apart from the employer's obligation to provide the committee with the information that it needs to complete the pay equity plan exercise. So fairly broad in scope. What happened in this case, though, is interesting. So CIBC, obviously large employer, had non-unionized employee reps on the committee and a union rep from the steelworkers. The non-unionized employee reps on the committee disagreed with the steelworkers about the type of information that was required. So what the commissioner said is, I don't have jurisdiction to hear this complaint from the steelworkers, this request for additional information, because it's a decision that is within the scope of the committee. And because the employee vote is split, because employee reps on the committee collectively have one vote, and it was split, so then the vote goes to the employer. And because of that, the commissioner doesn't have jurisdiction to intervene in that dispute. So it's not something that can properly be referred to her. So that is very interesting. If all of your employee reps on the committee agree, and there is a true dispute with the employee reps having one vote going one way and the employer going the other way, then conceivably it is an issue that the commissioner could intervene in. But in this case, she declined her jurisdiction for that reason. Another interesting, concerning case, which I will respectfully disagree with the commissioner on, is this PSAC case. So the PSAC wanted to appoint multiple representatives to the committee. So it represented one bargaining unit. But ultimately it said, well, okay, we want to actually, I think it represented one bargaining unit. In any event, it said, we think we have the discretion to appoint as many committee members as we want from the PSAC to the committee. The Bank of Canada said, no, as the employer, we get to decide the size of the committee and how it's constituted, which I think makes total sense. Keeping in mind, the employer is paying everyone to be on this committee. It's the employer representative, or sorry, it's the employer's responsibility to establish the committee. It's got to balance gender composition and all sorts of other things. It's got to facilitate these meetings, etc. Lots of reasons why it should be the employer prerogative. But unfortunately, the commissioner disagreed and said it was within the union's discretion to determine how many representatives it wants to appoint to the committee. At this stage, this is the only instance that I'm aware of, well, maybe one other one that's in the works, but the only instance that I'm aware of where this issue has been, has gone to the commissioner. I really worry though, that all the unions are going to talk about this case come maintenance time and that we're going to see a lot more requests. Derrick, how are your members reacting to this?
Well, I'm not a lawyer, so I'll give you my non-legal interpretation of this decision. It's complete nonsense. Agree with everything you've said. There was, I think, a general understanding in the employer community, particularly in organizations that have multiple unions, that it would be reasonable for each union to have a representative on the pay equity committee. That seems fair. But this decision opens the floodgates. So now work that is already complicated enough with large committees is going to get even worse if this trickles through. And unions start demanding extra seats at each committee. I foresee a complete nightmare. I've heard from a couple of members that are going through this now. This decision is going to be completely unhelpful.
Yeah, well, and I know too from seeing it happen in committees that as soon as one union shows up with 3 members representing it, all the other unions at the table say, oh, I want that too. And so suddenly you've gone from, I don't know, 3 union representatives to 9 union representatives, all of whom are taking paid time out of their regular job, and you've got to accommodate and reschedule and everything else in order to get them at this committee. So yeah, it's going to be a real challenge. Emilie, jump in.
Just a comment, and I know we could spend this whole session talking about pay equity, and I'm trying to hold back on my comments, but in this particular point, I find interesting that, you know, the Federal Pay Equity Act really inspired itself from the Ontario and Quebec experience. In the Quebec Pay Equity Act, there are really strict, you know, it's framed, the number of members in a committee are framed depending on whether there are unions, various unions. And so I'm surprised that the federal government didn't go that route. And I wonder whether that's something after this decision, whether that might be a possibility, that there might be amendments to the Pay Equity Act that may come into force just to come and frame that composition a bit more, because I agree with your conclusion. This is completely, you know, the fact that there's no limit seems completely irrational in a large workplace.
Yeah. With that, can I turn it over to you now to talk about maintenance? Because I know you've been very involved in maintenance in Quebec,
Yes.
which has been underway for a few years now. And so I'd love to hear a little bit about how you see the federal process playing out and to what extent it's similar or not to what you've seen in Quebec.
Perfect. Thank you, Jackie. If we can just go to the next slide, please. There was the annual reporting.
That was me, sorry.
It's okay, we'll
I
talk
jumped
about
the
maintenance in a
gun.
minute.
I'll quickly say on annual reporting, so I'll hold that thought on maintenance. Annual reporting, just a reminder to everyone that the first reports are going to be due June 30th, 2025. So coming up fairly soon. There was recently consultation from the commission about what that report would look like, but it does include a lot more information than what you include in your pay equity plan. So a lot of those pay equity plan details are there too, but you've also got to include additional information about, for example, the amount of the increases provided to each job class, the total number of employees who receive increases both under the plan and the percentage or the number of whom are actually women. My sense is that this information is going to be used to for sort of broader policy reasons by the commission. Certainly haven't seen any intention to publish it, which is good because that's information that would be quite sensitive. But just, yeah, an FYI that there will be broader information that you have to include in those. So with that, I'll turn it back to you. Sorry about that, Emilie.
Okay. Thanks, Jackie. Okay, so as many of you probably already know, pay equity, your pay equity plan will have to be updated 5 years from the posting of your final pay equity, your final posting for your initial pay equity. And so, for example, if you had to post by September 3rd, 2024, your date to post your final updated pay equity plan will be September 3rd, 2029. Between now and then, there will be quite a few other elements to address and to do before you get to that deadline. The first one being the Pay Equity Act. The Federal Pay Equity Act provides for a duty to post a notice informing employees of the employer's obligation to update the pay equity plan. This resembles a lot the posting that you had to do back in 2021 for your initial pay equity exercise. Therefore, if you have to put up in place a committee, you will have to inform unionized and non-unionized employees of this. For non-unionized employees, you have to inform them that they may name members on the committee. And for unionized employees, inform them that their unions will be naming representatives to the committee. And just as a reminder, so employers who at the maintenance stage reach the threshold of having 100 employees or more, or have unionized or have unions in their workforce, will have to set up a committee to do their pay equity update or maintenance, as I often call it. I just want to say a few words on this because there's an important distinction here with Quebec. And so the first one being, at the federal level, employers have a duty to recount the number of employees and determine whether they now have unionized employees within their workforce. The other distinction is regarding the number of employees, so the duty to have a committee. So these two elements, recounting and actually putting in place a committee, are two elements that are very different from Quebec. In Quebec, there is no duty to recount the number of employees in the workplace before an employer does their maintenance exercise. The duties of an employer are set up with the number of employees that they have on average when they became subject to the Pay Equity Act. So once we get to maintenance, let's say an employer had 10 to 49 employees when they started off and they became subject to the Pay Equity Act. For the life of the business, they will remain subject to those obligations regarding pay equity. So it does not take into account the increase in size of the workplace or whether the workplace becomes unionized through time. The other important distinction is that in Quebec, an employer who initially had a committee, so had to have a committee to do their initial pay equity exercise, can decide once they reach the maintenance stage, whether they want to do their maintenance alone or in a committee. If they decide to do it alone, they will have to do a participation process, and they also open themselves up to potential complaints from unions and from employees. And this is exactly what we have been seeing in Quebec. There has been enormous litigation when employers who had committees decide to do their maintenance alone. There has been, especially in unionized workplaces, we've seen a lot of litigation around maintenance exercises when it's been done alone by the employer. And overall, the pay equity maintenance section in Quebec has been the source of significant litigation and amendments throughout the years. And this is probably why the federal government decided to go this route and to force employers to do committees in these circumstances where the business could be growing or changing its size. So interestingly, at federal level, you could have a committee in your initial pay equity exercise, but then once you get to maintenance, maybe you no longer have an obligation to have a committee. So having this variable sizing analysis is a very interesting development at the federal level. And just to continue on what needs to be done at the federal level for the pay equity maintenance. So when the employer or the committee updates the pay equity plan, the federal employer has to set out in a document any changes that are made to the plan. This is also something that's distinct from Quebec. And subsequently, the employer, once this analysis has been done and they've determined, they updated the pay equity plan, the employer or the committee has to respect the same posting obligations as they had during their initial pay equity exercise. So there's a 60-day posting of the draft or the revised pay equity plan, the draft of the revised pay equity plan. Also 60 days of posting for the document that sets out the changes of the revised plan, and of the notice informing employees of their right to comment. So during the 60-day period, employees can write their comments to the employer regarding the draft revised pay equity plan or the document that sets out the changes. The employer then has, like in the initial exercise, has a duty to consider these comments in finalizing their pay equity plan. And the final version of the revised pay equity plan and the document setting out the changes must be posted no later than the 5th anniversary of the day on which the employer posted the final version of their first pay equity plan. And in the event that there is pay inequities that arise from the analysis of the pay equity maintenance during the last 5-year period, the amount, so the remuneration will have to be adjusted, and there will be a lump sum amount that will have to be paid for those inequities that arose in the last 5 years. So there's a retroactive aspect to the adjustments that will need to be done. So this is a reminder for federal employers to keep and stay very vigilant on situations that may lead to inequities during the following years. So now we've just completed the initial, things may occur. So always stay vigilant, and this is also what we recommend to employers at the provincial level. And so this also appears to be a very similar approach to what we see in Quebec since 2019. So since 2019 in Quebec, there's also a retroactive adjustment for any inequities that arose during the last 5 years. Prior to 2019 in Quebec, any adjustments were only made, so every 5 years employers would have to do the maintenance, and they would only adjust for the future. This has led to serious, very important litigation that went all the way to the Supreme Court and has led to significant amendments to the law in 2019 in Quebec. And finally, if amounts are owed, employers will have to inform employees through a notice of the date of when the adjustments will be paid, or the lump sum payments will be paid to the employees. So generally, I would say, there's not much information on the Pay Equity Commission's website on maintenance. It's been announced that further information will be provided to federal employers. We expect that the Federal Pay Equity Commission will continue to inspire themselves from the experiences in Quebec and Ontario to determine these new guidelines and directives for the maintenance exercise at the federal level. I don't know if Derrick or Jackie, if you had any additional comments on pay equity maintenance. It could also be an entire presentation.
Yeah, thanks, Emilie. My only observation is I would think it's fair to say that there are many, and I don't know the number, of course, that's not publicly available, employers out there who are still drinking from the fire hose or trying to get the pay equity plan done in the first place. So when we look at dates like the annual report due June 30th of 2025, well, that assumes there's actually a pay equity plan in place by then. And then the same thing on the maintenance review when we start counting that 5-year period. This is all very valuable information. I would venture to guess there's a whole bunch of employers out there still scratching their heads, trying to actually get the work done to get the plan in place in the first place.
Yeah, and just to that comment, Derrick, regarding the 2029 date, I believe we will see a similar situation where if employers need to extend the date for a reason, they will have to request an extension to the commission, but then will be expected to pay interest if any adjustments are owed for certain periods going beyond the 2029 period.
I actually think the maintenance exercise is going to be more challenging than the initial exercise for a lot of employers, particularly employers who are not on a formalized those employers who have less structured compensation regimes, let's put it that way. Those who have very structured regimes and they can monitor and track how job classes compare to each other and make sure everyone's sort of sticking within the parameters that they were established in the pay equity plan, that's going to be a relatively easy exercise. Although obviously every time a union bargains big increases, it's going to throw everything into question again. But I think where those employers who are going to have the most challenges are those that are in less structured regimes, because the second you add a new job class, you change a compensation plan, whatever it might be, you come up with a bespoke arrangement for one employee, the whole thing can go out of whack so quickly. And now you're going back 5 years instead of just making adjustments going forward. So the costs are just going to skyrocket. On that happy note, I'll turn to employment equity very quickly. If I can change the slide, there we go, perfect. So just more to get on your radar than anything. Almost this time last year, December last year, the ESC or the government released their report, the task force report. It had been a long time coming. It included extensive proposed amendments to the Employment Equity Act, including recommending a new committee, a workplace committee, those sorts of things. We haven't seen those ideas picked up, but what we've seen a couple of the ideas coming out of that act picked up, including in the budget. And there was recently ESDC doing consultation with employers on this issue. But what they're looking at in particular is adding 2 new designated groups to the Employment Equity Act. So Black people and 2 SLGBTQI+ people. So new designated groups that employers would have to report on, just like the existing designated groups. There's also some much needed updates to terminology. So for example, replacing the term Aboriginal peoples with Indigenous peoples and redefining that to be more reflective of modern legislative descriptions elsewhere. Also replacing the term members of visible minorities with racialized people, and aligning the definition of people with disabilities with the Accessible Canada Act. So a few things under consideration, and I don't know, Derrick, do you have any sense on when we'll see these amendments?
Well, we've been very supportive of the government modernizing the Employment Equity Act because it was about 25 or 30 years old. So we've actually been, as an employer community, pushing the government for 10 or 12 years to do this. So pleased to see that they launched the task force to do this work. And as you say, the report they came up with was very expansive. And the government has sort of nibbled at the edges of it with the changes that they are about to recommend. The terminology and the definitions, I mean, that's just been such a long time coming. It is a welcome change for sure. We don't know what's coming next. The one challenge I would say that still exists, that was still not addressed in this massive report written by the task force, is the fact that employment equity is based on self-identification by employees. And we have employers around the country who are held to task for not being to the standard that they should be in the representation of certain designated groups, even though they know their scores are higher than they are. They can't report on that because self-identification is all that they can use. So if an employee decides that they don't want to check the box, they don't want to fill out the survey, you can't count them. And that is a critical problem that employers have been raising to the government for more than a decade. And sadly, this task force did not speak to it. And it is a challenge that we know is going to only get further exacerbated moving forward when we add 2 new designated groups to this list. Look, employers are fully supportive of this. DEI initiatives, particularly across our membership, are very important and take high profile. And frankly, we think this is all a good thing. But when the government holds employers to account for not reaching a certain standard, when in some cases they know they are reaching the standard, but they can't report on it, that becomes problematic for sure.
Thank you, Derrick. Human Rights Commission changes. I'll be very fast on this. Otherwise, my poor colleague Gillian won't have any time to update us on the cases, which there's actually been a lot of activity in that space. So really quickly, there's been a lot of things going on at the Canadian Human Rights Commission, not all good. So they've had an internal systemic discrimination complaint. They're most recent commissioner was appointed and stepped down before he even really took on the role. So there's a lot, I think, that they're dealing with internally. A couple things I wanted to flag though for employers is that what we're seeing come out of the commission when they're reviewing settlement agreements between parties is what we've heard from them is that they've sort of developed internal best practices that include heightened scrutiny around standard confidentiality clauses and releases. So for example, they're reluctant to agree to confidentiality clauses that are one way, that are only employer sided, or releases that go beyond releasing the employer in respect of that complaint and extend more broadly to all complaints. What from my perspective was actually pretty standard language in these kinds of agreements, but we're seeing pushback on there. So something to get on your radar. They're also really looking for evidence of training, particularly with those involved in the complaint. So they want to see that employers have already done training for the managers involved or whomever, the other employees involved, whoever it might be. And if not, then ensuring that that training is part of the settlement agreement. We're also seeing them referring cases to the CHRT, to the tribunal, or to conciliation without doing an investigation. We'll see how that process plays out, see where they're using it and not. It's still something new on my radar, but something I want to flag for employers and something a little bit concerning as well, obviously. So stay tuned for more as we see that process go forward and potentially judicial reviews of those decisions. Chris, did you want to jump in?
I'm happy to turn to paid medical leave.
Perfect.
To move this along. And I'm going to make some high-level comments that I think are relevant to both unionized and non-union employers, and then ask Derrick to jump in here. Suffice to say that I think the federal employer community broadly continues to have challenges with respect to the implementation of paid medical leave. And one of the biggest issues continues to be, how does the new paid medical leave under Part 3 of the Code interact with existing paid leave entitlements provided, whether under a collective agreement or an employer contract or an employer's policy? It's still not clear what the law is here. And we've continued to have very inconsistent guidance provided by the federal government with respect to when an employer can count an existing paid leave entitlement towards the new statutory entitlement. And we've seen a bit of litigation over the course of the last year. 2 reported decisions have come out that very helpfully reach kind of inconsistent results. Both of these are labor arbitration decisions, but I think they're also relevant to non-union employers. First decision was a case called Cameco, released in December of 2023. That was a very employer favorable decision. In that case, the arbitrator found that you don't need perfect symmetry between the existing leave entitlement and paid medical leave to count the former towards the latter. And there, the arbitrator counted a generous but different short-term disability plan towards and some other entitlements towards the paid medical leave entitlements, said employees aren't entitled to any additional statutory leave. Unfortunately, about 4 months later, we got a decision out of Alberta in a case called Purelator, where the arbitrator applied what I think is a different line of reasoning, and essentially said that you must be dealing with virtually identical leave entitlements, the existing paid leave entitlement and the statutory entitlement, to count the former towards the latter. And if there's any differences between the two, you can't count the paid leave entitlement towards the statutory entitlement, and the employees get both. And in that case, the employer was dealing with a collective agreement paid personal day. And despite the existence of that paid personal day, very generous to employees, allowed them to use it for basically any reason. The arbitrator said, it's not the same as the paid medical leave entitlement, the employees get both. These are the only reported cases that are really floating around out there right now, but there is lots of litigation that's progressing in arbitration processes, in adjudications. So we'll really have to see, we'll really have to wait and see what the future holds. A couple of best practices that we do have, and I just focus on number 3 here, is that while in many cases, I think that you can argue that something like an STD plan should count towards the paid medical leave benefit, the case law is very clear that as it stands, it is risky. It is risky, unfortunately, to have a paid leave entitlement that is different, even if it's more generous than paid medical leave, because you may not get to count it towards the paid medical leave statutory entitlement if you get into a fight over it. Derrick, do you have anything to add on this front?
Yeah, Chris, I mean, this is probably the issue on which I've gotten the most calls from the employer community over the past couple of years. No one in our membership is opposed to paid leave for employees in circumstances of illness. But what this legislation has resulted in, and we actually predicted these very things when the legislation was being developed, but our concerns were essentially ignored, is that we are seeing a massive increase in the amount of paid sick leave that is being taken by employees. There is a labor productivity crisis in some of our organizations. There are patterns, because we pulled the data, where we're seeing the preponderance of paid sick leave taken on Mondays or Fridays or around other statutory holiday entitlements. So that to us seems like a very weird coincidence. There are 3 key challenges that we have been lobbying aggressively for the government to address since this came into force. The one is the one you spoke around the stacking piece. We have members who have paid leave provisions in place that have historically been used for circumstances of illness, but now they don't count as paid sick leave. So that the 10-day stack on top of the entitlements that already exist within the organization. The second piece is the inability to ask for medical certification of illness. The legislation requires that an employee must be off for 5 consecutive days before an employer can ask for a doctor's note. So that sort of check against any sort of abuse that the employer may find exists within the organization is gone because it's no longer permitted. And the third piece is really just the magnitude. I mean, it's not clear to us how we came up with 10 days. It was during COVID when the minister at the time determined that this legislation would be 10 days of paid medical leave. Obviously, at that point in time, we were all isolating for 10 days when we came into contact with COVID-19. So maybe that's where the 10 came from. For some employers, particularly in the small and medium-sized employer community, 10 days is huge. And the cost to them has become really substantial and the operational challenge significant because they just can't get enough people at work. So this is an ongoing challenge. It's a fight we've been engaging with the government on for more than 2 years now, quite unsuccessfully, but it's one that we're going to keep beating the drum on because this problem is not going away and these labor productivity challenges are just getting worse.
Thanks, Derrick. Jill, over to you for some case law.
Okay, I like to think they saved the best for last, but I won't bore you with the details of too many cases given the timing constraints here, but I will just give an update on unjust dismissals and then review a few civil cases over the past year. So with respect to unjust dismissals, most complaints are being referred to hearings and not decided based on the written submissions of the parties. To be quite candid, I've honestly never seen a hearing on the merits decided by way of writing. They're almost always holding a hearing. They need the evidence, the viva voce evidence. So I don't think we're going to see a reversion in any sense here to hearings by way of writing. We've said here the complaints are typically being heard in 24 plus months. I think 24 months is on the low end. I think it is not uncommon these days to have a hearing on the merits take place 3-4 years after the termination has occurred, which is particularly problematic given that back pay is dated back to the date of termination in most cases. And I think one of the issues we're currently seeing is this lack of clarity about calculating damages where reinstatement's not appropriate. So there's a number of cases where reinstatement is either not appropriate or reinstatement is no longer desired as of the date of the hearing. Previously, we were seeing the CIRB calculating notice on the basis of the common law standard, so common law reasonable notice, which would be 1.5 months per year of service. There was a decision a couple of years ago which has effectively shifted that model, and we're now looking at an economic loss model, which effectively says that you should be treating non-unionized employees as if they are unionized and subject to a collective agreement. So you should be recognizing that employment is effectively for life. And so it says that you should assume that the employee would remain in their job until their expected retirement date, subject to certain contingencies such as the employee's age. So if they're particularly young, I don't think they would look to a retirement date at age 65 to calculate damages. They also look at the tenure and position with the employer, the employee's health, projected length of time before retirement, and the likelihood of the employee potentially being dismissed for cause in the future based on their past conduct or past behavior. So I think this is concerning for a lot of employers because the stakes are already high enough with unjust dismissal with the potential for reinstatement. And to think on top of that, to have to potentially award damages for years into the future is a big concern for a lot of employers. Another thing to note is that we are seeing increasing cost award. So the federal court has recently affirmed that the CIRB has the ability to award substantial indemnity costs. And effectively, I think what they're saying here is that employees shouldn't be dissuaded from bringing legitimate unjust dismissal complaints in cases where the potential actual value of the damages to be awarded are low relative to the costs of bringing the complaint forward. So this was usually in situations where someone has obtained reemployment elsewhere, and so they're actually looking for only for back pay between the date of termination, the date they started employment elsewhere, and damages are fixed in that sense. And effectively, they're saying an employer should not have the ability to kind of evade unjust dismissal complaints because employees won't bring them on the basis that the legal fees are simply too high. And so we should be aware that cost awards may be increasing going into the future here. So in terms of cases, so you will be pleased to know that employers do still have cause in many situations. It may not feel like it on a day-to-day basis, but there are cases where cause is still upheld. And I think this Morton and Royal Bank of Canada decision is really just affirming that, particularly for financial institutions, cases of egregious misconduct in singular incidents is still cause for termination. So this was an 18-year employee who manipulated transactions to gain nearly $100,000 of unearned fees, bonuses, and commissions. Their role involved managing client accounts, and they were obviously expected to adhere to the bank's code of conduct and the bank's compensation guide. So an internal investigation found that the employee had bypassed automated processes and rebalanced client funds and engaged in manual transactions that falsely inflated her commissions. She denied the misconduct and she very carelessly and recklessly disregarded the code of conduct. And again, as I said, I think this is just confirmation that single instances of egregious misconduct will lead to cause for termination in many cases. And I'm happy Emilie can jump in if I misstate anything in the CPKC and Sauvé decision, because she was the one who actually successfully argued the case. But I think the important thing to recognize in this case is that the federal court has essentially confirmed that a relationship that may have been a sexual or personal relationship that may have previously been a consensual relationship can change over time, given the context and the content of communications. Essentially, the federal court said that whether or not sexual conduct and words are welcome or tolerated can vary over time and with their content. So in other words, whether certain behavior amounts to sexual harassment can change over time depending on the relationship between the parties. And Emilie, I don't know if you want to jump in here and provide any context in the case here.
The file is going back to arbitration, so I think I will refrain from commenting on the substance of the decision, but that's one of the important points that came out of this decision. I think it was an excellent decision for a Federal Court of Appeal decision. It was the first time that they were really setting out clearly what the criteria were for sexual harassment in the workplace and how to analyze those types of situation. And one of those points was exactly the point that you just raised, Gillian. So I think that's one of the very important it's a very important decision for that reason. It really comes and sets out the criteria and the guidelines to analyze those types of situations.
Yeah, I think here, so this was a case dealing with a manager and their direct subordinate. And so also looking at the hierarchical relationship between the parties and how that could potentially impact consent in a relationship as well was another important comment that the federal court made, or the Federal Court of Appeal made in that circumstance as well. I don't want to get people's hopes up too much here, but there was actually a very helpful decision from the BC Court of Appeal that found that there was an enforceable termination clause in an employment agreement. It was a very simple termination provision that effectively said the employer could terminate the employee's employment at any time without cause, so long as it provides appropriate notice and severance in accordance with the requirements of the Canada Labour Code. So really very simple. And I think the court's analysis was very helpful. It essentially said you need to apply a practical, common sense approach to contractual interpretation. The clause was very clear. The employee knew what he was getting when he entered into it, and it was not ambiguous or non-compliant in any way. I think this case, particularly for federally regulated employers that have a lot of employees in Ontario, the case may not be extremely helpful, as the Ontario courts seem to do anything they possibly can to invalidate termination provisions. But I think it is a helpful case in the sense that it really goes back to basics, and that if you know what you're getting when you enter an employment agreement, that's what you should get upon termination. So that was a very helpful decision from the BC Court of Appeal. And then I think I'll probably just review this one last case here, but effectively the court said that you don't need, this is the Kimpatik and Thunder Bay Electronics Limited case from the Ontario Court of Appeal. The court effectively said that an employee does not need to have a diagnosable mental health condition in order to claim moral or aggravated damages arising from termination. If an employer's conduct in the course of termination is egregious, dishonest, or anything of that nature, and the employee can show that they caused harm beyond the normal distress that arises from a termination, they can be entitled to moral or aggravated damages. And so in this situation, during the termination meeting, and I should say that the employee was terminated 2 hours after returning from a medical leave of absence for a back surgery that they actually needed as a result of employment sustained injuries. So it was 2 hours after returning from a leave of absence and the employer terminated. The employer gave the rationale that financial reasons were the basis for termination, yet they refused to provide any financial information at the trial. And so the court said that the rationale for termination was more so that the employee could no longer perform the manual tasks because of his back issues. And so they found the manner of termination to be high-handed and dishonest. And the employee, he was 59 years old at the age of termination, had been employed for 30 years. And so the court found that he suffered harm that was beyond the normal harm that would be suffered in the course of a termination, and awarded $50,000 in aggravated damages. So I think I'll leave it at that for Chris to wrap up.
Why, thanks, Gillian, and thanks everyone for joining us today. As the Fasken team always tries to do, we've wrapped up right on time to get you back to dealing with these things in real life. We hope that does not make you sad. Certainly, I hope this hasn't been too depressing a presentation, and I'm hopeful that 2025 will, mark an upward trajectory in the federal sector for employers. But I would be remiss before thinking about 2025 if I didn't thank my co-speakers, and in particular Derrick, for joining us today. Tiny bit of housekeeping before we call this completely to an end. So the link for the Ontario and Quebec Law Society certificates is on your screen and in the chat, and that's along with the HRPA code. You should be able to find it all there. For anyone viewing from BC, the Law Society of BC title has been added to the chat as well. The next webinar in our fall series is on November 26th on the even more happy topic of managing workplace absenteeism, legal insight for employers. If you'd like to sign up for this event, the link has been added to the audience chat, and I do promise you that it will be a more joyful experience than everything you've heard from us today. You can find registration for any of our events and playback previous events in the events section of fasken.com. And with that, thank you all for coming. Have a great day and see you in 2025.